Good evening, everybody. Welcome to the following program. Tonight, we're going to do a deep dive expose into a friend of Fani. A Fani friend. That's right. Big fat Fani Willis got friends. She got friends, and one of them, district court judge, got exposed. And she got bounced. That's right. Forced to actually bounce herself after she basically was exposed for, in her own office, believe it or not, exposing and bouncing herself. Plus showing her political partisanship and lying. All this and more. It was an exciting day today. That's what I really want to focus on. I want to break down for you this entire sordid scandal. We're gonna glom past some of the rough edges there, some of the disgusting, filthy depravity that was happening inside a judge's chambers. Some of that we might glom past a little bit, just because it's a family-friendly show. But I'm definitely going to break down for you the humiliation that has befallen Fani World and how it actually is an important case that she's gotten bounced out of. And a very important case. In fact, we should start off by talking about that. It's a case that's going down in the state of Georgia, Macon County, in the middle of Georgia there. There's a case which is called United States versus Raffensperger. This is a case you should care about. The objective in this case is the DOJ went to the state of Georgia and they said, hey, we want to review your voter rolls because we got some questions. We got to do like a little investigation here in order to ensure that we're going to have election integrity. And your voter rolls, we got wind of the fact that there are potentially problems here. So we want to be able to match up driver's licenses to your voter registration and age and who's living where. So this way, we have reasons to suspect that your sloppy voter rolls are enabling election fraud. We don't like that. We don't want no fraud. So we'd like to actually inspect that stuff. And naturally, Brad Raffensperger, schmuck that he is and always has been, said no. That's a violation of their privacy. Yeah, because obviously sharing that information with the state government, if you're an individual, sharing with the state government, you feel like, oh, state government, I'd be totally fine sharing it with, not the federal government. What? That don't even make no sense. Who the hell is like, oh, I'm going to register to vote, but only if the state knows about me, not if the federal government does. This is a transparently empty, stupid, ridiculous defense that Brad Raffensperger, rhino that he is, bounced out of office, Brad Raffensperger, I should add, thankfully, because he's a schmuck. So Brad Raffensperger said, no. We don't want to have the DOJ looking over our shoulder. We don't want them to know what is happening in the state of Georgia. These are the Republicans. Remember, they're the ones these are our friends, right? Remember in 2020 when that whole ridiculous thing happened with the elections there in 2020, Brad Raffensperger was like, oh, there's nothing to see here. While they're dropping thousands of freshly minted ballots. No, everything. Cleanest election ever. And then tried going after Trump, claiming that Trump was trying to strong arm him into twisting the election with that notorious 1 hour, 2 minute long phone call, which had 47 people on the phone with him. Okay, it was actually 11 or 12, but you get the point where he was secretly trying to strong arm into breaking the law and changing votes for him. That ridiculous thing which led to the indictment down in Georgia. You remember the indictment. That indictment is what introduced us to Fani Willis. We got to learn all about Fani Willis and her stinking relationship with Nathan Wade and how the two of them were all smoochy while going after Donald Trump, and the ridiculous block billing hours where he's billing for, 14 hours at a time, 16 hours at a time by basically saying research or whatever nonsense he would write there with the lousiest attorney billing imaginable. Just the worst, lamest attorney billing imaginable. Yeah. So yeah, we saw all that. That's where we got to meet Fani Willis. You likely remember Fani Willis, that she was the one who basically, when her sordid relationship was brought to the attention of the court, that the court basically ended up having an evidentiary hearing, and this crazy lunatic woman who would go up giving speeches about how white people are coming after us, getting up in church, and she was exposed for that, which one reason or another, Judge Scott McAfee decides just ignore all of that ridiculousness. But he did end up saying ultimately in that particular case, this is obviously referring to the indictment of Trump down in Georgia, he ended up saying, as you're well aware, that either Nathan Wade has got to go, or there's that Fani Willis has got to go, because he said that the relationship there and the ongoing situation, the nature of everything here, has what he called an odor of mendacity. And that odor of mendacity was coming into the courtroom and just stinking up the whole place. And he said, we can't have an odor of mendacity here. It just doesn't feel, it doesn't feel like something kosher at all. It just doesn't feel like that. So he said, one of you has got to go. That's what he said. One of you has got to go. Which is what left Nathan Wade to say, oh, okay, well, I'm out of here. And he basically ended up living. You remember all this, right? You remember Fani Willis coming there with the pink dress on backwards, taking the stand and basically swearing, that she's got piles of cash that she back at her house, that she doesn't know why there's piles of cash there, but there is, that she used to pay back Nathan Wade, and how she wasn't actually benefiting from their intimate, hidden, discreet, sordid relationship. The late night meetings till 2 a.m. with Nathan Wade, when nothing's going on. That's what she's trying to say. Nothing was going on. You remember Fani. Fani, District Attorney Fani Willis from Fulton County. She's not in this case, United States versus Raffensperger. So let's be clear about that. She's not involved in this case. No. Well, she wasn't involved. Let me strike that. She wasn't involved. She became involved because she sent an invite to a judge who's presiding over this case, that invite being District Court Judge Eleanor Ross. Now, until recently, nobody realized that there was anything related to this case specifically. In fact, no one even really knew that it was Eleanor Ross. I got a lot of details to break down for you, a lot. This is just, I'm giving you the backstory here. Because Eleanor Ross, who happened to be randomly assigned to the case of United States versus Raffensperger, turns out that she's besties with the infamous, notorious, and big fat Fani there. So they're really good friends, really close friends. And she was the one who was presiding over this case, where the DOJ is looking to basically sniff around inside all of the dirty laundry that Brad Raffensperger got going on with his voting rolls. You can well imagine. She's not exactly going to be someone who's, thoroughly as impartial as we might be seeking. Well, anyhow, a motion was brought to help get her out. We're going to break down we're going to break down the motion, what it's based on, and we're going to break down the actual findings as to just how perverse and disturbing this judge is. You're going to ask yourself, by the time we're all said and done, how the hell is she still a judge? How is this how is this our jurisprudence? I don't know. It is, though. This is what we take what we got. She still is a judge. I wish I could tell you otherwise, but that's the reality of the situation. Oh, yeah, I also forgot to tell you. I got a goal going on tonight. I'm supposed to tell you about goals. If I don't tell you about goals, how do you know to reach for the stars? You wouldn't even know to reach for the stars. I got to set goals for you. So this way you know to reach for the stars. Tonight's goal is, if in fact we hit 15 super chats in quantities of $10 or more, I'm going to go into an hour 3 where I'm going to be covering all sorts of news for you guys. I got Antifa being busted. I got JD Vance going on these world tours. I got burning crosses. I didn't even mention. I got attempted assassination at the UFC on his 80th birthday. We got stories to cover. All that and more if we hit our goal. That goal is 15 super chats or Rumble Rants or, shekel, local donations, Venmo, PayPal, whatever, in quantities of $10 or more. We do that, we hit our goal. Voila. We go to hour 3. If we do, great. If not, c'est la vie. Anyhow, I want to start off tonight. By talking to you all about how this whole thing came together. And really, I think that it's fair to start I'm still torn even as we're going through with this. I guess it's fair to start by talking about this release that came out of a federal of a final report that came out. Let's start with the final report. And the final report, when this came out, nobody knew who this report was about. We now know today that it was about Judge Eleanor Ross, the one who's presiding over the case United States versus Raffensperger. But when this report first came out, we did not know anything about who it was. It came out from the 11th Judicial Circuit, and specifically what that report. Now, this is the 11th Judicial Circuit. Understand, this is a circuit court finding. This is the court. This is one step below the Supreme Court. These people are pretty. They're pretty high up in our judicial system, the ones who are making this finding. Okay, so 11th Circuit comes to this finding about one of their judges. They say on September 30th, 2025, Chief Circuit Court Judge William H. Pryor identified a judicial complaint against the United States District Court judge. And they say, we got this report. We got all these complaints about a report. And we don't want to tell you who the report is because who this person is. We want to try and protect this judge's privacy. So we're not going to tell you who it is. Now, if you ask me, I don't think that the 11th Circuit should have been doing this. When you're making a finding of issues as grave and as serious as what some of the findings that they have, to protect her by not disclosing who it is that this order is referring to, I think it's an unfair disrespect for Americans. I think it's treating you and me like we're crap, like we don't need to know who this is. And it's, you would say protect the dignity of the court. And the dignity of the court isn't being disgraced by our knowledge. It's by her conduct. It's by her disgusting behavior. We're going to learn all about her disgusting behavior. So I want to sort of jump on into this report. Look at how they have all these different. It's a 22-page report, including some. It's technically, I guess they call it 20, but it's really it's long. It's a little bit of a long report. So when I'm breaking this down for you, if you have questions, feel free to raise your hand, and I'll call on you in turn. So the subject judge in United States District Court, September 2025, the chief judge of the subject judge's court. See how they keep calling her subject judge? It's subject judge. We don't want to tell you who it is. We'll just call her subject judge Ross. We'll just call her that. So they received certain information that subject judge Ross had engaged in a judicial misconduct by, among other things, engaging in an extramarital affair with a law enforcement officer. She got a head cop. And in the course of having her affair, having sexual intercourse in her own freaking office during work hours and within hearing distance of the judge's clerks. Yeah. She's basically putting on an audio show for her clerks. That's what this woman is doing. Judge Eleanor Ross. The chief judge relayed this information, saying, this doesn't sound like things she's supposed to be doing. The subject judge promptly denied them. Thereafter, Chief Judge Pryor identified complaints of judicial misconduct on the Judicial Conduct and Disability Act and appointed a special committee to investigate the complaint. Oh, you're going to deny it? Oh, you think that's going to work for you, Judgy? You think that's going to work? You're going to just deny it? Oh, we're going to let it go? No. Special committee retained counsel to assist in the investigation. During its investigation, the committee corroborated the primary allegation regarding the affair and the sexual activity in chambers. And in the midst of the investigation, it just got worse for her because the subject judge recanted the initial denial, admitted to the affair with law enforcement officers, saying, "Please stop investigating me. Yes, it's true." And she admitted the intercourse in her office during work hours. She also eventually admitted another allegation that Judge Ross attended a partisan political event. This is a very big no-no. It doesn't look good. It doesn't look as if we actually have fair and impartial judges when they go to political events, especially if some of the people whose political events they go to end up coming before them in court. In light of the information gathered during the investigation, including the subject judge's admissions, the special committee finds that she engaged in misconduct by one, engaging in the above described affair, in chambers, yes, in her office, attending the partisan political events, and three, making false statements to, among others, Chief Judge Pryor. So she basically tried lying to his superior when she got busted. Yeah. The special committee recommends that the Judicial Council issue the subject judge a private reprimand. This is the final thing. What we should be doing is private reprimand. And also, she agreed to, number one, issue letters of apology to certain law clerks who basically are suffering from PTSD as a result of listening to her having sex in her office. Two, decline to serve as chief judge of the district court when the judge would otherwise be eligible to do so. So you're never going to become chief judge. That's it. And three, indefinitely refrain from serving on any judicial conference committee. I am sorry, 11th Circuit. And it's very nice that you did this whole report. This is ridiculously light. Oh, we're never going to allow this sick, twisted individual who's having an affair in her office during office hours, like leaving behind a trail of coitus noises for her clerks to eavesdrop on, and engaging in political activity, that she won't be chief judge? Really? She has to write an apology. Oh, boo-hoo! She got to write an apology. She can't serve on a judicial conference committee. This is nothing. How is she not suspended? How do you not suspend her? I mean, frankly, she should have her judgeship pulled from her altogether. So let's not kid ourselves. They should be like, after this, you're done. We're not having you sit on a case. All right. We're not going to get into the factual and procedural history. We're going to skip past that because it's, it just talks about how the report came in and how there was a letter to the subject judge, and that Judge Pryor sent her a letter saying that, hey, there's allegations against you that on February 27, 2025, this is just last year, also May 29, 2025, other occasions, that you took a cop into your office and were basically doing all sorts of nasties with him while employees in your chambers could hear you. They could hear you. And that you failed to provide the clerks with proper supervision, yet yelled, cursed, and engaged in abusive conduct toward your staff on more than one occasion. So basically, they all hate you because you're kind of a bitch. Not a surprise. And immediately after you presided over a criminal hearing, you told an intern that you had too many martinis the night before. And what may have been a political event for a district attorney. District Attorney Fani Willis, specifically. In addition to responding to the factual allegations, Pryor asked that she address whether the judge engaged in additional misconduct and cited provisions the alleged conduct may have violated. And then she was supposed to get back a response on by October 20, 2025. So they gave her 3 weeks. Sent it to her on the 29th. They gave her 3 weeks to respond. They said, tell us, these are the allegations against you. Tell us what we got. What's your position? So first she sends a response. Later that same day, she submitted a response. And she says, "This is outrageous. It's baseless. None of this is true." This is outrageous. Oh my gosh, how can you say such a thing about me? Not me. Apparently aware that law clerk A, and we're going to deal with law clerks A, B, and C, was the source of the allegations. So there's three clerks here. She thinks that she's got one problem, one law clerk that she don't like. No. She has problems, plural. The subject judge noted that the judge had repeatedly chastised law clerk A for performance issues, including being on the clerk's cell phone in court and in the office, arriving to the office late, and wearing a tie the judge considered too casual. The judge implied the law clerk A may have made allegations and means retaliating. So this is like she's just making this stuff up. She's not. None of this is true. Why would you say such a thing about little old me? You can't believe her. She just hates me because I'm trying to kick her in line because she's a terrible clerk. She sent that back the same day. Jill sent 2 emails to the district judge at 9:54 a.m. So literally that morning, the first thing, as soon as she got the notification, because it came in, she got the notice September 29th. Before 10 a.m., she already sent out a couple emails saying, "Good morning. I was just now told that one of my law clerks has accused me of some very inappropriate conduct, including the way I treat my law clerks. I also received a letter from Chief Judge Pryor. I'm astounded and confused and have no idea what this clerk is referring to or why the clerk made such allegations. Little old me. I'm such a good girl." At least that's why I tell the cop to call me. My only thought is that because I spoke with the same law clerk about being on the clerk's phone in court, I wanted the clerk to work in the office rather than remotely. The clerk is upset with me, so this is just revenge retaliation. And like a complete idiot, my career clerk said the career clerk had no idea what I was talking about. I invite you to please do a full investigation, including speaking with all of my staff. As you may imagine, I'm very upset about this. I'm not quite sure what steps to take next. Well, you already took one bad step. In a subsequent email, just 14 minutes later, she denied knowing the identity of the alleged visitor chambers, right? And because so many lawyers, law students, and officers, there's so many people coming in and out of here. My office is like a train station. I don't know what's going on. There's just so many people coming in and out of here. How can I possibly know? I don't even know who you're talking about. There's so many people. I got like a little turnstile. People got to take a number. You want to come in and see me? It's very, very busy in here. Very, very busy. I don't know which law enforcement office the clerk is referring to, or the clerk alleges it was different officers. I don't know what's happening here. So, are you able to get that to me? Because I don't have that. If you can get that to me. Yeah. The subject judge suggests the law clerk A was retaliating, blah, blah, blah. The following day, Judge Ross sent a follow-up email. In it, she speculated that law clerk A may have been motivated to fabricate information in retaliation for having to be working in the office. So after getting this response, Chief Judge Pryor entered an order pursuant to Rule 5A saying, "You want an investigation? I'll give you your freaking investigation. We're going to do the investigation, and here we go." And they got a special committee, retained experienced counsel to assist in conducting its investigation, and so it went. And when the investigation happened, surprise, surprise, it took various steps in the voluntary unsworn interviews and relevant documents, inspecting her chambers. They got like a little CSI thing here. They got the black light going on. I'm not kidding. They really did this. They're inspecting her. They did like a whole black light thing, trying to see what fluids are on her couch. They took this very seriously. This is a thing, I guess. Inspecting the layout of the chambers, determine whether the law clerk sitting outside the judge's office could hear the noises that the law clerk claimed to hear. This is a freaking... Oh my God. Removing the sofa cushion from the subject judge's chambers and arranging for a qualified biological laboratory to conduct an acid fast phosphate test of the cushion to determine whether semen was raised. Oh my God. Oh my God. Reviewing court security footage. Visitor sign-in logs determine whether a law enforcement officer had visited. Examining court records determine whether her relationship with a law enforcement officer might give rise to a conflict of interest in appearance of conflict. Searching publicly available information regarding a political event. So they really did their work. They look. No one can say that the 11th Circuit, the committee appointed by the 11th Circuit, did not do their homework. They did their homework. They were digging in. Yes. And this is what they found. Joe be nice, yelling, oh my God, harder and harder. It's protected by freedom of religion. Don't judge me. Get it? I said judge. Don't judge me. I see that. It just proves it's a loving place to work. Yes. It's very, very warm environment. Sometimes someone call it a hot environment. Someone say it's an environment that's going straight to hell. When I was reading this, I was just like, I can't even believe this. I can't even believe what's happening here. I can't even think about this. By the way, I will ask you, if you're here and you can hit the like, subscribe, all those other buttons, that'd be good. Apparently, algorithm isn't liking me lately, so I'm supposed to like remind you of that more. I should stop having this scroll thing. I should have it like dancing, like this, the little banner on the thing. Just like the little scroll chicka chicka, scroll chicka chicka, scroll chicka chicka. Maybe the color isn't good also. Should I change the color? Let's change the color, right? I don't even know. What's the color of the band? I don't even know. Oh, that's whatever. It is what it is. So they start corroborating stuff. And they review sign-in logs and all the camera footage. And they revealed that an officer of a certain police department had made frequent visits to her chambers during the preceding years. Some of those visits occurred on specific dates the law clerk A provided to the chief district judge. So I was starting to see a little match here. Generally visited around lunchtime, came in uniform, stored a weapon in the locker near the main security entrance, and signed into and out of the courthouse using the law enforcement sign-in logs. According to the police department website, the officer currently serves as commander of a certain division. Officer has worked for the PD since 1998. And on the LinkedIn profile, the officer has held that role as a commander. He's a division commander. He's not like some, beat cop. No, this guy's, some would say he's big stuff. Interviews of law clerks. Each of the six former clerks interviewed recalled seeing a visitor come into chambers whose description generally matched this officer. Yes. So they all saw him go in. 3 remembered firsthand overhearing what may have been sexual activity occurring in her office. First, one law clerk B, described an incident occurring in either late 2022 or early 2023. When the clerk heard, coming from the judge's office, sounds of music playing and the judge talking with a visitor. At some point, the conversation stopped, and the clerk could only hear the music. However, law clerk B had not seen anyone leave the judge's office, causing the clerk to conclude the judge and visitor may have engaged in intimate contact. Then you got law clerk C, describing 2 occasions in which the clerk heard unsettling noises coming from the judge's office. First one happened in June 2024. These are different incidents, by the way, from the one that clerk A is talking about, because the one clerk A is talking about both happened in 2025. They're seeing stuff happening. This is going on for years. This woman doing this for years. So it's 2022, 2023, 2024. They all seen it. On that day, law clerk C heard music and voices coming from the judge's office. After a period of time, law clerk C heard only music. Like law clerk B, C did not see anyone exit the judge's chambers when the voices stopped, and the second instance occurred in August 2024. That time, law clerk C heard what sounded like kissing sounds. I don't know, like how loud do you have to be kissing that it would be like through a door? It would be like, it's very strange. kissing sounds coming from the judge's office. Law Clerk C assumed on both occasions that the visitor to the office was not the subject judge's spouse, as both times the visitor entered the office through the back door. And everyone knows that there's very little chance that her husband would be allowed to come through the back door. As is relevant below in Section 2, the misconduct findings, Law Clerk C reported that on September 29, 2025, after receiving Chief Judge prior letter, the subject judge telephoned Law Clerk C. During the resulting conversation, Law Clerk C advised Judge Ross that the clerk had once heard kissing sounds coming from the office. So after she got it, she's like, what do you know? What do you know? Tell me what you know. I want to know what you know. Remember how I said like 14 minutes apart and like right away she's responding? Yeah, you know what she's doing in between? She's grilling her law clerk. I said grilling with a G. What did you hear? What do you know? The third clerk who reported hearing sounds in contact was Law Clerk A, repeated for investigation counsel the information the clerk previously provided to the Chief District Judge. Hearing the subject judge engaging in intimate contact in the judge's office had a significant and negative effect on the above described clerks, as one would imagine. Law Clerk A recalled losing focus at work, being unable to sleep. So you picture her tossing and turning. Law Clerk A was concerned about how the subject judge's conduct, if it came to light publicly, might adversely affect the public's view of the judiciary. Well, you know what would adversely affect the public's view of the judiciary? If they see this stuff, expose it, and give her nothing slap on the wrist, which is what they did. Idiots. So stupid. Law Clerk C said the clerk was made very uncomfortable by what the clerk heard coming from the judge's office. Law Clerk B stated the clerk was so unsettled by the noises that they had to leave the office for the day. Like, I can't even be here. I can't be. This is disgusting. I can't be around this. Even those who do not have firsthand exposure to the sounds, the visitor described as being adversely affected by the judge's conduct. A former career clerk who functioned as a quasi-supervisor term clerks recalled two different term clerks asking for advice after hearing the judge and the visitor. So this is an ongoing, recurring pattern in a most disturbing way. And she's very obviously lying to us when she says she doesn't know what they're talking about. Amazing Grace says, my liberal family members finally cracked. My brother finally made it to me that he doesn't support anything the Democrats stand for. I'm overjoyed. What other options does he have? Ha, 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 ha. Send him a link. It's really that simple. It's really that simple. Send him a link. Was I supposed to have Branka in here? Wasn't here last week? Supposed to have Branka? I forgot. We said third Tuesday? Third Tuesday? I forgot. I don't know. You get older, things just forgot. They start slipping. I don't know what to tell you. I need like someone to give me like a calendar or something. The former career clerk described feeling powerless to prevent term clerks from exposure to the relationship. Another term clerk said the clerk's colleagues frequently discussed what the judge and the officer were doing behind closed doors, leading an awkward working environment. So everyone knows. I think look at how long this is going on, and she got nothing. What was her punishment? You're never going to be a district judge, and you can't be on committees, and then issue letters of apology. That's it. This is stupid. This is so stupid. This is not justice. This is not justice. This is insane. Such utter abuse of power. Testing the sofa cushion. As for the cushion, after moving the cushion on October 3rd, 2025, on October 7th, counsel transported the cushion to qualified laboratory. There, the laboratory director conducted an acid phosphate test, which returned a negative result. So, there's so much depravity in there. They're like, wow, there's definitely going to be male issue on baked into the couch, and they were surprise came back negative. So no, I guess it was effective cleanup, one way or another. Effective cleanup. I'll let you reason out how that happened. Then they researched into conflicts, and they did a poor job, honestly, with respect to potential case conflicts. They determined from the January 1 to October 10th, the subject judge did not preside over any case in which either the officer or the police department was a party. As for possible PD witnesses testifying before the subject judge during this period of the intimate relationship, the judge presided over several criminal trials. It does not appear that any police officer testified at any of those that a police officer testified. So they're basically trying to say, no, it didn't. It didn't affect any of her cases. That's wrong. It's wrong. But we'll see. During the period of intimate relationship, the judge denied a motion to suppress evidence in a case in which the conduct of a police officer was at issue. So they wanted to suppress. So maybe, however, the officer was no longer with the police department at the time of the suppression hearing. It does not appear that the officer had any involvement in the case. So it could be. So there was a case where a defendant said, "Hey, there was an illegal search that this police department did. We want to see evidence suppressed," and she ruled in favor of the cops. Said, "No, we're not suppressing it." So they basically are saying, you might think that the reason she's doing that is to be nice to her smoochy backdoor visitor, and they said, but it doesn't appear that the officer had any involvement in the case or supervised the officer involved, so it doesn't seem as if their relationship likely had any impact on her decision there to try and do favors to her favorite visitor. But then we get to the section 2, information about the subject judge's attendance at political events. You understand this, Uzelian. At this point, when they release this report, no one knows who the judge is. Today we do. But that's not what the 11th Circuit ever wanted us to find out. The 11th Circuit was hopeful no one would ever figure out who this judge was. That was their objective, was trying and protect her, the sanctity of her, of her judgeship. And this is the type of corruption which is disgusting. It's horrible. They're just covering up for her. And they don't give any real punishment. 3 former clerks recalled the subject saying that that the judge had consumed martinis at a victory party for a district attorney. They don't tell us which district attorney. We now know it was Fani Willis. The episode reportedly occurred on the judge's summer intern's first day. The morning the subject judge presided over a criminal revocation proceeding, 2 clerks took the interns to observe the hearing. Afterwards, the clerks met with the interns in Chamber Library. During the meeting, Judge Ross came into the room and told the interns that the judge was going home and would not be able to join them for lunch. According to the 2 clerks present and a third who heard the conversation, Judge Ross explained that she had consumed too many martinis the night before. She was all drinking, was sloppy drunk at a primary election victory for a district attorney. So she's name dropping, trying to say, look how important I am, that I'm going to district attorneys, like an idiot, and not realizing that that's a complete breach of her duties to remain impartial by showing that type of bias. 2 of the clerks reported being mortified by the judge's comments. I don't know if they're mortified by how drunk she was showing up to work, or that she's going to Fani Willis's party, or they're mortified at the notion as to trying to imagine what would happen at a Fani Willis party. There's a lot of things to be mortified about. There's a lot to be mortified about. Based on news coverage, including video and photos, the district attorney's campaign held an election watch party at which drinks or food in martini glasses appeared to have been served. The special committee did not locate any photographs depicting Judge Ross at this event, but that would later change. That's going to happen soon. They didn't dig up any pictures of her. That doesn't mean there ain't any. And in fact, we're going to learn soon there is. As for the staff treatment and staff supervision allegation, on behalf of the special committee, questioned the former law clerk's supervision aspect of the alleged allegation related primarily to civil casework. And her practice was to handle all criminal casework without law clerk assistance. Each of the 6 former law clerks interviewed reported that when assigning a clerk to work on some substantive civil motion, the judge did not indicate to the clerk how the judge was inclined to rule on the motion, otherwise provide any direction. So basically, justice is being meted out by the clerks themselves. She has no opinion. It was generally understood that the judge did not wish to discuss civil case with clerks. The Judge Ross rarely, if ever, substantively edited civil orders. So basically, justice in civil cases before her are being meted out by clerks, not by her. They're just stamping her signature on it. Multiple clerks. She's still a judge now. She's working tomorrow morning as a judge. Multiple clerks stated that given their inexperience, they were uncomfortable with the level of discretion that appeared to exercise in handling civil cases. Because they never were sworn in as judges, and she's treating them as judges. Clerks were generally unaware as to whether the subject judge reviewed pleadings or draft civil orders. The former career clerk recalled one instance in which, during the middle of a civil trial, Judge Ross made a comment indicating that the judge had recently, for the first time, read the order denying summary judgment in the case. So she's the one who denied summary judgment. Her signature was slapped on it, and she had never even freaking read the case. She never even read the decision. She's still a judge now. Zero accountability. Zero. This is on the 11th Circuit. How the heck you just let her continue to go out there? You say, well, we're never going to let you be chief judge. So? Hey, what an embarrassment for the 11th Circuit. Law Clerk A stated that on multiple occasions, the judge emailed the clerk. And by the way, it also reflects on Chief Justice Roberts. When he sees this, he should be like, what the heck are you doing? Why are you allowing this woman to continue meting out justice when she's not even acting as a judge? When civil cases, she just hands the ball off to her clerks and say, you handle it. You write up decisions, grant or deny summary judgment motions, and stamp my signature on it. And if I have to read it, I'll read it later. This is not a judge. It's not a judge. Do your job. Law Clerk A stated that on multiple occasions, the judge emailed the clerk to docket an order within a few minutes of receiving it, and indicating the judge may not have time to read it. They give her a 30-page decision, tell her to sign it, and she's never seen it before. And 4 minutes later, she's like, okay, docket it, meaning enter it. This is not a judge. The special committee did not gather any information that would substantiate the staff treatment aspect of the allegation. Law Clerk A just basically says she's a jerk. Anyhow. So then she ends up basically, when she gives her response on October 10th, after having some time to reflect, and that she admitted to having an extramarital affair with the officer, admitted in the course of the affair that she basically was performing those activities in her office, and she maintained the denials of the other allegations about the whole party. So basically, she's a big fat liar and has no integrity whatsoever. On that first issue, Judge Ross stated that the intimate relationship with the officer began in either late 2022 or early 2023. What is with these people? It's like the court system is just basically, it's just like, it's like, you got this judge with police officers, you got Fani Willis with Nathan Wade. What the heck is happening in Georgia? With the Georgia judiciary. The subject judge terminated the affair by the date of the supplemental response, and neither admitted nor denying engaging in activity with the officer while staff members were present. So basically just pled the fifth on that. I would think so. She's no integrity at all. She just lies and lies. Whatever she thinks is going to help her, she's going to lie. The subject judge acknowledged that the police officers may have appeared before the judge during that period, but that the judge had no recollection of that occurring. And about her alleged attendance at a political event, the subject judge acknowledged having been friends with Fani Willis since 1999. She knows her for 25 years. Ross asserted that the judge has never attended a partisan political event with or for District Attorney Fani Willis. Ross stated that on one occasion, at the District Attorney's invitation, the judge went to a mixer of former employees of a District Attorney's office where the sub-judge previously worked. This event reportedly occurred before the District Attorney's victory party at a separate location from the victory party, which the judge did not attend. Sub-judge contended this mixer was not a political or campaign event and that there was no admission fee. Turning to the judges related to the law clerk treatment and supervision, and she gave her other answers on that. I don't really care about that. She just gave general denials. So then they expanded the investigation further. And the specific additional allegation was that she demonstrated a lack of candor in the way she responded, because she was basically, you lied to us. What do you mean? You can't change your position altogether. The order expanding the scope of the investigation noted that in communications to both chief judges that she falsely denied having had, basically using her office as a hotel room, and suggested the law clerk, and also lied about the clerk, saying that the clerk made false allegations. And they told her to respond by November 14th. So then the judge, now proceeding pro se, provided additional written submissions and participated in a voluntary interview with the investigation counsel. And the judge and the information subject judge provided both in writing and orally pertained primarily to the judge's attendance at Fani Willis's party, the allegation that she made false statements, and this is basically what she said. During the interview, the judge admitted that the district attorney event could reasonably be considered a political function. You think? You think? The subject judge said that the district attorney verbally invited the judge to attend, although initially hesitant to accept the invitation. She ultimately did so based on their assurances that the private mixer would be separate from the political function. Apparently, there was the odor of mendacity coming from Fani Willis as to whether or not it was political. On the evening of the event, the sub-judge arrived at the venue later than intended. During the interview, the judge noted that upon arrival, the judge had to pass through a lobby area adorned with campaign signs. By the time the subject judge arrived, the district attorney was already leaving the mixer and moving to the campaign event, which was being held in a different location in the same venue. So she didn't interact with Fani Willis. Instead, she visited with former district attorney office colleagues, leaving after about 45 minutes. As the subject judge was leaving, the judge picked up an appetizer that was served in a martini glass. And then she drank that and then said some white wine. The subject judge wrote the following day, someone sent the judge a photograph in which the judge can be seen holding the martini glass in which the appetizer was served. According to the subject judge, the next day, the judge showed the photograph to some of the judge's staff members. So she's all proud of herself. Sub-judge reiterated that the judge had never consumed a martini. However, the judge conceded that it was possible that she joked about having had martinis with the district attorney since it was her event. It's possible. She had to leave sick early that day, but it's possible she joked and made it up. During the interview, she insisted that any comment the judge made about having had a late night would have been in jest. Nevertheless, the sub-judge continued to refrain from engaging in banter with staff going forward. She described personally thinking that it was appropriate to attend the event because no fundraising events occur in the room, no one made any political speeches, and she didn't personally endorse the district attorney or any other political candidates. But even if it's apolitical, it's part of a larger function that was undoubtedly partisan. In response to the lack of candor allegations, the judge explained that when sending the initial response, the judge was shocked, humiliated, and fearful of the impact the information would have on the judge's personal life, especially the judge's already troubled marriage. I was afraid it would ruin my marriage. What, the fact that you're like exposed for like for boinking a cop in your office? And it caused her to rashly react and submit responses containing false statements. So basically, if she's cornered, she lies. Sub-judge further clarified that when reviewing Chief Judge Pryor's letter, the judge's attention focused on allegations the judge had yelled and cursed staff members because she knew those to be untrue and suspected the law clerk A had fabricated those claims as means of retaliation. No, that's not what you wrote. And she ended up admitting that this in no way justifies the absolute dishonesty in denying the sexual misconduct. At the end of the response, the judge asked the special committee to take into account the judge's prompt recantation of the false statements. Subject judge pointed to her other. The only reason she recanted is because she found out that her clerks ratted her out. That's why. That's why. That's the only reason. You know it. That's the only reason she's recanting. She's a big fat stinking liar. Lazy judge. Doesn't do any of the civil work. Berating her staff. Boinking in her chambers. Hanging out at parties with and bragging about how she's hanging out at parties with Fani Willis. Complete abuse of power. And they're protecting her in so many different ways. There's no real punishment. They tried to veil who she was. They tried to basically hide from the public. The public would never know that this was Judge Eleanor Ross. That's what the 11th Circuit did. This is the problem. The problem is not even Judge Ross. The problem is the 11th Circuit. The problem is that the judges overseeing this basically tried to protect and insulate her as much as possible, not giving her any real punishment. Again, in case you joined late, for all this conduct that she engaged in, the three things, basically she carried on a years-long affair where she was having this affair in her chambers within hearing distance of her clerks. She's not doing her civil work. That's being done by other people. She doesn't even seem to be reading the cases. She's attending political events with Fani Willis, which is completely against ethical rules for a judge as far as participating in political events. And then when she's cornered on this stuff, she lies about it. So what does the 11th Circuit do? They say, we're not going to let anyone know who you are. We're going to shield your identity. Well, when we have to make this report public, but we'll shield your identity by referring to you as the subject judge. And your real punishment here is you need to write apology letters to the clerks who had to listen to you banging some cop, and you're never going to be a district judge, and you can't be on judiciary committees. But she might not even have any aspirations for either of those things. So there's nothing. There's zero punishment here. Zero punishment. And that's a tragic reflection on the 11th Circuit. You see a judge who's incompetent and corrupt and lazy and lacking in any integrity. And when she's busted, you do nothing about it. Nothing. Zero. So people want to know why it is that. So why wouldn't another judge do the exact same thing? Why wouldn't this be a rampant problem? If you know that there's not going to be any repercussions, why would that stop any judge? There's no repercussions. There's no punishment. There's no nothing here. And in fact, now there's no nothing here. They'll even try and protect your identity when you're busted, so that no one would look down on you. This is shameless. It's disgusting. It's really disgusting. It's even more disgusting than Judge Eleanor Ross is what the 11th Circuit did with this. Some judge then attributed some unspecified portion of the gap in time between September 29 and October 10 to the judge's efforts to retain counsel and advice the judge received from attorneys, concluding the judge intended to recant the initial response well before the redaction letter was submitted, and she concluded by again addressing the utter remorse for her initial dishonesty. Now, what about the civil case work? So she reported making edits between 30 and 40% of draft orders. Half of them she doesn't look at. 30, 40% of them she'll like change a line here or there. She said that she just assigns it to a clerk, and she doesn't offer clerks guidance in advance as to whether motion should be granted or denied. She just lets them decide. And that's the only way she can handle her caseload. I got too much work. I have a large volume of cases. She challenged the assertion of being unavailable to answer clerks' substantive legal questions, writing that the judge is always available, whether in or out of the office. Judge Ross said that same day during the interview reports that clerks often came to the judge to discuss tricky issues. Towards the end of the written response, judge suggested that during a recent period involving very sensitive family issues, judge was not as engaged or affable as the judge needed to be. So he's admitting that she basically was off partying and doing whatever the hell she wanted with her own personal life. And they still let her keep working. Nothing. No punishment. And she's accepting responsibility for her failings. Let's just stop it. So that's how they have their misconduct findings. Based on this entire report, they find that she engaged in an extramarital affair with a high-ranking police officer. In the course of that affair, having sexual intercourse in her chambers during business hours within hearing distance of a traumatized staff, and going to Big Fat Fanny's parties and lying. Before explaining these misconduct findings, the committee notes that it does not find that sub-judge engaged in misconduct in the supervision or treatment of staff, although the committee is troubled by the assertion that the sub-judge is not engaged in the resolution of civil cases. It's not just her resolution. She admitted it. She said she only does 30 to 40% of them. And indeed, by the judge's own admission of such a lack of engagement, the facts established do not support a finding of judicial misconduct. What would? What the hell would? She's not doing her job. There's not misconduct. There's no conduct. The special committee, this is so outrageous, takes the subject judge at judge's word that going forward, she will endeavor to be more engaged in civil cases. Oh, just stop it. She just said she couldn't do it because of her volume. What's going to change? You're going to lower her caseload? As for the staff treatment allegations, no above, the special committee did not gather any information that would support a finding that the judge's treatment of staff constituted judicial misconduct. She's admitted she's incompetent and can't get the job done the way she needs to. And she's corrupt and she lies. The committee is confident that with the increased level of engagement from the subject judge, some of the workplace atmosphere concerns raised by the clerks will dissipate. What nonsense. So they say that the committee is confident with the subject judge and that some of the workplace atmosphere concerns. So here's an interesting little story. When interviewed, Judge Ross expressed dismay at law clerk A having falsely accused the judge on multiple occasions, yelling and cursing at staff. As stated, the special committee does not make any finding of misconduct regarding how she treated her staff. Nevertheless, for clarity purposes, the following explains the origin of the allegation. During a meeting with the chief district judge, law clerk A described that to the chief district judge of the July 23rd, 2025 meeting summarized above, in which the Judge Ross reported being unbothered if clerks called the judge a blank. Law Clerk A told the Chief District Judge that, according to a co-clerk during the previous year, Judge Ross had acted similarly. In the Chief District Judge memo to Chief Judge Pryor, the Chief District Judge wrote, the law clerk indicates that the judge has on one account displayed visible anger, including yelling and cursing, directed towards the judge's staff, in which the clerk perceived to be unwarranted circumstances. The Chief District Judge then described in detail Law Clerk A's account at that July 23rd meeting. And after doing so, the Chief District Judge wrote, at this point, the other term clerk reached out to law clerk saying the same thing had happened the previous year. In a letter to Judge Ross, Judge Pryor summarized the allegations as follows. You yelled, cursed, and engaged in abusive conduct toward your staff on more than one occasion. So we don't find there's anything wrong here, even though we're recognizing that she is cursing at her staff. Chief Judge Pryor's statement was a fair summary of the Chief District Judge's memo. Law Clerk A had indeed suggested to the Chief District Judge that Ross had engaged in yelling and cursing more than once. However, the letter omitted the fact that the Law Clerk A had admitted having personal knowledge of only one such instance, and that on that occasion, Ross had not directed profanity words towards staff. So she's just generally vile. In short, Law Clerk A allegations were not untrue. However, it's understandable how Judge Ross, reading the one-sentence summary, later perceived them as being such. Yeah, this is giving her every possible benefit of the doubt. And it doesn't even matter, even giving her the benefit of the doubt. This is ridiculous. So they end up finding that she was having this affair, and the police officer undoubtedly was involved in numerous criminal civil cases litigated in the district, and that Judge Ross did not disclose the affair to any other judge, court staff member, or litigating party. Accordingly, the undisclosed affair created the possibility that Judge Ross would be assigned to handle a case in which the officer or the officer's employing agency had an interest, thus creating conflict or appearance of one. Although no such scenario occurred, it appears to be a result of happenstance and not any mitigating efforts. So she got lucky. Far more troubling, on multiple occasions, their relationship, Judge Ross and the officer, while in her chambers and during business hours, engaged in intimate conduct, including by the judge's own admission, sexual intercourse. They did so within earshot of the clerk assigned to work outside the subject judge's office. At least 3 of her clerks had heard sounds resulting from intimate contact, and the experiences adversely affected them, as one would imagine it would. Then we have her conduct regarding the relationship, particularly when it came to sexual activity in chambers, demonstrated a gross lack of judgment. And when they say gross lack of judgment, trust me, it was gross and it was lacking judgment. Regarding of whether the subject judge intended to do so, the judge created a chamber workplace that was extremely uncomfortable and troubling for clerks. You think? As Judge Ross admitted in written submissions, it was the judge's job as judge to provide the best working environment possible. All judges owe the same to those who give their time and talents to serve the judiciary. And she fell well short of that mark, and we don't care. We're not going to punish her at all. It was not only the law clerks who suffered from the judge's behavior, so too did the courts. The judge's staff understandably was distracted from their job duties while having to write her civil decisions for her by concerns that she's basically going to boink anyone who walks through her office door. It also, it's like you have to mark anyone who goes into her office, mark them safe. It's also worth noting that the subject judge created a vulnerability to extortion. For 2 years, the judge was a federal district judge who routinely heard criminal cases, engaged in secret extramarital relationship with prominent officer of the law enforcement agency, with the affair consisting of intercourse in her chambers during working hours. So yeah, this is something that makes you very ripe to be extorted. Undoubtedly, a bad actor could have used these acts to try and blackmail her judge. Even absent a blackmail attempt, the publication of these facts would have greatly damaged her credibility as a judge and brought disrepute to the federal judiciary. And now we have greater disrepute because you refuse to punish her. Judge Ross' behavior violated multiple provisions of the Code of Conduct for United States judges. Canon 2 says judge should avoid impropriety and appearance of impropriety, respect and comply with the law, and should act in all times in manners that promotes public confidence and integrity and impartiality. And 2A further explains that public confidence is eroded by irresponsible or improper conduct by judges, including harassment or other inappropriate workplace behavior. Was that wrong? Was that really wrong? Was I really supposed to leave all my clothes on while he was in my office? Is it wrong? Totally wrong? The commentary to Canon 1 makes clear not every violation of the code shall lead to disciplinary action, and that whether disciplinary action is appropriate and degree of discipline should be determined through a reasonable application of the text, and it should depend on such factors as the seriousness of the improper activity, the intent of the judge, whether there's a pattern of improper activity. We have all of these things. We have a pattern. It's very serious. And the effect of the improper activity on others in the judicial system, which is basically traumatizing her own clerks and exposing her to being blackmailed. She doesn't have time to do her civil work because she's too busy boinking an officer. I don't have time. I have a workload. You know how much work it is satisfying that guy who comes visit my office? I don't have time. How can I handle it? There's too much to do. Applying these factors, so it's clear it's appropriate. As described above, the misconduct that occurred here was serious. Oh, it had significant effect on multiple members. It was going on for a long time. It's not an isolated incident. The appropriate degree of discipline is addressed in Section 3. Then they say there's misconduct with the going to Fani Willis thing. And they found that there was a political party, and the judge said that only for purposes of reunite. We credit the judge's assertions that she only went there for purposes of reuniting with the former colleagues and did not speak publicly. So we don't think it's that bad that she went. The fact remains that overarching purpose of the larger event, of which the mixer was part, was to promote District Attorney Fani Willis. Moreover, which they don't want to say Fani Willis's name because that might help you figure out that they're talking about Judge Ross. Moreover, in light of the sub-judge's concession, absent any evidence to the contrary, the special committee finds the larger event was sponsored by the district attorney's campaign donors. The Code of Conduct makes clear that the sub-judge should not have attended. Canon 5 says, refrain from political activity, and explicitly prohibits judge from attending a dinner or other event sponsored by a political organization or candidate. So she's just completely ignoring that because she figures she can do whatever the hell she wants to. Political organization includes a group affiliated with a political party or candidate for public office. He can't attend any public meeting, rally, or otherwise associate himself or herself, even when the candidate is the judge's spouse. But this, we think, is a one-time lapse in judgment, not part of a larger pattern. Nevertheless, the fact is set forth in Canon 1 counsel in favor of misconduct finding. Importantly, this is an interesting thing. Judge Ross's attendance at a political event where someone photographed the judge had the potential to erode public confidence in the independent, nonpartisan nature of the judiciary. Again, it appears to be a mere matter of good fortune that Judge Ross's attendance did not garner media attention. It's a miracle that no one knows. Nevertheless, the potential harm was significant and warrants a finding of misconduct. And then she lied to us. And she lied and she lied. And she said she never engaged in sex in her office. She's not sure who this allegation is about. And that she lied and lied to them. And that's her lies are a violation of Rule 4A5, which provides cognizable misconduct, including refusing without good cause shown to cooperate in the investigation of the complaint. And a duty to report your own misconduct to the relevant chief judge. Not only did she not fail to report it, and then she tried covering it up with her stupid lies. Undoubtedly, public confidence in the judiciary would be significantly diminished were the public to perceive that judges not expect the same truthfulness from each other, which you apparently don't care whether she lies to you because you gave her no punishment. And her eventual recantation might go to the ultimate sanction, but contrary to the judge's assertions, does not absolve the judge of liability. Even if the special committee were to adopt this principle, the subject judge articulates in one of the judge's responses that recantation is defense to false statement liability. The principle would not excuse the judge's conduct. Importantly, two conditions must be present for the defense to apply. Namely, the falsity has not affected the course of proceedings, and the recantation came before the declarant knew that the untruth would be exposed. Neither is present here. By October 10th, when she's recanting at that point, we had already invested a lot of time in this whole thing. We already knew what everything she's admitting to us. As noted above, by that time, Investigation Counsel, on behalf of special committees, had, among other things, reviewed courthouse security camera footage, reviewed courthouse sign-in logs, conducted background research on the officer, interviewed 5 of the subjects subject to former clubs. We knew all about it. She basically, by the time she confessed, we already knew. So what the hell is her recantation doing? Most of these efforts would have been rendered unnecessary had the Judge Ross just been honest in the beginning, but she doesn't know how to do that. So it affected the course of our proceeding, and moreover, there's a high likelihood that when she first submitted, the judge knew that the falsehood had been or would soon be exposed. By that point, Judge Ross was aware the Investigation Counsel had removed the cushion from her office. And while a stain ultimately tested negative, apparently there's these disgusting, gross stains. Oh, gross. Oh, no. Oh, no. Oh, God. Why? You didn't mention stains earlier. I just thought it was random testing of the couch. No. There's a specific, oh, my, can you just get, oh, gosh. Imagine you walk into Judge Ross's office and you know you're one of her clerks. And it's like, and you see on the couch this stain, this stain there. Imagine you are one of her clerks. And you come in there and she's like, well, we should discuss this. Have a seat. And you're like, I don't know what that is. Can you just imagine? Just think, what the heck is this office? What is happening in these chambers? She's inviting people into her chambers. It gives a whole different connotation to being invited to judges' chambers. It's like all of a sudden, chambers need a chamber bed. I'm good. I'm good standing. You've been on your feet all day. How to take your? No, I'm good. I'm good. It's like all the clerks know when you get like a new clerk coming in there, you tell them, don't sit on the cushion closest to the left armrest. Don't. Just don't. Disgusting. It's so disgusting. I didn't realize there was a stain. Unbelievable. Joe. Was the officer involved white? Did she call him her Ford Bronco? Did she just need to brush up on her law of self-defense? She wanted all 5 elements of self-defense thrust upon her. This is, to answer your question, the answer is no. Unlikely. And probably yes. Given her admissions, it seems to be reasonably likely that the judge feared the test might return a positive result. In fact, all of us are kind of mystified that it didn't return a positive result. We were pretty sure we knew what was on that cushion. When they came back with the lab report saying negative, we were like, really? Really? You want to double check your test there? Really? Did you check for maybe it wasn't male fluid? I don't know. Additionally, as noted above on September 29th, former law clerk C informed sub-judge clerk and 2 had also heard intimate contact noises. So she knew. She knew that her clerk said, hey, yeah, I heard you. I heard you. It's kind of disturbing. The subject judge submitted the first supplemental response on October 10th. Judge Ross likely and reasonably assumed that law clerk C had shared or would share the information with the investigative counsel. So she's like, oh my God, she's going to rat me out. She's going to rat me out. So that's why she came and recanted. So what the hell is her recantation? It's nothing. And also, the investigation counsel acts as the officer's LinkedIn profile. Counsel doing so may have set off a notification to the officer. So she's like, oh my God. He basically said, hey, by the way, that committee is checking my LinkedIn. So they know. They know. If this occurred and the officer shared that with Judge Ross, that information would have further suggested that the special committee was well aware of just what a sick, perverted individual she was. So, in short, while the special committee appreciates her eventual candor, it's useless. So, we're going to have any real punishment here? No. Recommend sanction. In light of this, we recommend that the judge counsel issue a private reprimand. So, give her a stern talking to. Judge Ross informed Chief Judge Pryor that the judge would not oppose or challenge this sanction. Ooh. Judge Ross also agreed to issue letters of apology to the 6 former law clerks who had to suffer through listening to her do what she does, and forego service as a chief judge if she's otherwise eligible to serve in that capacity. Nothing. This is stupid. What? And indefinitely refrain from service on a judicial conference committee. This is so stupid. Given that we've made no findings of misconduct, related sub-judge treatment, or supervision of staff, we do not consider appropriate to recommend that require a core human resources staff person to conduct periodic meetings. However, we encourage Judge Ross to perform such periodic check-ins. Oh my God, they did nothing to her. She got away with this completely. Special committee carefully consider whether to recommend more severe sanction, including a public reprimand. The following mitigating factors dissuade. Why is she still working? Dissuade the committee from making such recommendation. 1, Judge Ross's correction of the judge's false statements as subsequent candidate with special committee. She knew you knew, and you just said that's meaningless. Who cares? She right before you announced that you knew, she's like, "Oh, I'm sorry, I apologize, I lied to you." 2, the unlikeliness that judge will engage in similar misconduct in the future, evidenced by the judge's discontinued relationship with the officer. How do you even know that happened? She says so? She already proved to you she'll lie to you. And 3, the sub-judge's otherwise exemplary service on the court. You mean where she basically pawns off at least 60 to 70% of all civil cases, if not more, completely onto her clerks? And says that it's too much of a workload, I can't do it? This is ridiculous. This is ridiculous. Although we're deeply troubled by the conduct in which Judge engaged, she's demonstrated a strong propensity for rehabilitation and continued diligent service to the judiciary. You suck. 11th Circuit, you stink. You're useless. Although the sanction recommended allows sub-judge to continue judicial service, the sanction also reflects the seriousness of her misconduct and provides solace to those harmed by that misconduct. It doesn't provide solace to anyone. It fills me with rage. That's what it does. It fills me with rage. This is humiliation for the 11th Circuit. And it's frank, by reflection, it's a reflection on Chief Justice Roberts as well. You're in charge of these idiots. This is just humiliating. Humiliating. All right. So this was their findings. This is what they gave us. Now, this came out on February 11, 2026. At the time, no one knew who this was. Just as you saw, it says subject judge, subject judge. No one knew to read as Judge Eleanor Ross. But then things leaked. So you want to know more? We got more. It got leaked out. Federal District Court Judge fornicated with Atlanta PD Deputy Chief in chambers. In 2023, revealed to the current Sheriff of Fulton County, previously moonlighted as a gay softcore star. We have more distressing and pathetic information out of Atlanta, as Law 360, Reuters, and Bloomberg have all reported to the Judicial Council 11th Circuit issued a ruling on May 22nd, which affirmed a limp-wristed reprimand released in February that lets a sitting federal district judge off the hook. Federal judge had basically engaged in this relationship for years in her chambers with current deputy chief of the Atlanta PD. The judge even gets to remain anonymous, at least by 11th Circuit, that is. But Marco Polo is not the self-protecting Judicial Council 11th Circuit. Good on you, Marco Polo. Eleanor Ross. Judge Eleanor Ross. There she is in all her disturbing glory. Fortunately, this picture is not the image that those who, her special visitors who came through her back door were observing. And that would be Deputy Chief Kelly Collier. That is who Marco Polo is reporting is the visitor. Judge Ross's backdoor visitor. Yes. Yes. And Ashley Merchant came out with this on May 27th. Blue dress busted. It's always a blue dress, isn't it? It's always a blue dress. That's her with a martini in her hand at the party, standing behind Nathan Wade. I think this is the guy that was actually called in the case to testify against Wade and was like sitting there basically saying he doesn't remember anything with his dishonest ridiculousness. They testified. I think this is his former law partner. So slimy. It's like a den of thieves. Disgusting. Now, this doesn't, to me, to be fair, this woman over here, who Ashley Merchant, she appears in front of these judges, so she would know. It does not look to me to be the same woman as this. But I don't know. This picture looked old. This picture looked old to me. This may look old. This could be old. But she says it's her over here. This woman looks like she's like 20 years older. I don't know. Maybe you can't see, her hair is pulled back. You can't see nothing. I don't know. But she got the infamous martini. And yeah. So if there was any doubt, the lady in the blue dress, federal district court judge Eleanor Ross, stand behind Nathan Wade at Fani Willis' primary night campaign event. So there you go. That's Ashley Merchant exposing Judge Ross and confirming that it's her. And I'm glad. We should embarrass the 11th Circuit for this slap in the wrist they gave. Not even a slap in the wrist. It's not even a slap in the wrist. There's nothing. There's nothing that happened to her. There was no punishment at all. Well, anyway, so this was on May 27th, which you might note was only like, what, 3 weeks ago? It was 3 weeks ago, which brings us back to where we started this story. Because we started this story talking about Judge Eleanor Ross. We started this story by talking about the case of U.S. versus Raffensperger. Now, in case you joined late, shame on you, but I'll catch you up to speed anyway, because I'm that kind of podcaster. I started the stream off by informing you all that A, you should hit like and subscribe, and we still have a goal going of that we need to get, that I'm going to go to hour 3 if and cover like all sorts of different new cool news stories if in fact we hit our goal, which is 15 super chats in quantities to $10 or more. And I'm not going to kid you. I feel like we're behind. I feel like we're behind in the goal. It's never too late. I feel like we're behind. But I also told you that this all comes to us today because of the case of U.S. versus Raffensperger. What's the case of U.S. versus Raffensperger? Well, that is where our DOJ is looking to access voter records in order to ensure integrity in the Georgia election system. So they want to have access to driver's license and voter registration so they can actually make sure that they don't have lousy voter rolls that allow for voter fraud. And Republican, rhino, sicko, overseer of the 2020 debacle, Brad Raffensperger, said, no, I'm not letting you do that because it's invasive. It's not fair to the voters that they feel as if that their information is being scrutinized. I also pointed out how retarded that claim was, considering the fact that this is information that they willingly gave to the state government. I've never met an individual who says, oh, I'm totally fine with giving information to the state government, but not to the federal government. Maybe there's someone out there like that, but to pretend that that's something that's an invasion of their privacy, that this information that they willingly gave to the state government, that they would be unwilling to give the federal government, is a lie. It is hot garbage. And it's basically meant to help cover up your own corruption. Woodtick Mike says, I found a link to an Instagram post, but someone deleted it. It's not, if not real, it's a good reenactment. I found a link to an Instagram post. He said that a few times. Let me see what he got here. Thank you, Woodtick Mike. You're awesome. I'm going to give an NSFW warning about what we're about to hear. I don't know if that's real or not. I don't know if that's real or not. Someone needs to tell her inside voices. Inside voices. Wow. Wow. All right. Well, anyhow, so I was informing you all that in the case U.S. versus Raffensperger, which is about voter election integrity, they were like, I don't think that we want this judge who's like besties with Fani Willis. Fani Willis, who is basically trying to go after Trump with all sorts of claims about election stuff. And now she's going to decide the DOJ, whether or not DOJ should access election integrity when that whole thing related to election integrity in 2020. So now she's going to decide this when she's besties with Trump. That doesn't make no sense. That don't make no sense at all. Can't have that. So the DOJ, once they learned that that case was about that reprimand was going out to Judge Eleanor Ross, they learned that on May 28th, May 27th. And by May 28th, actually by May 29th, they filed this motion saying, she gotta be recused. You gotta recuse yourself. You are not fit to, you're too close to Fani Willis. You're hanging out, you're violating your rules to go hang out at her political events. You can't be there. So U.S. respects, they brought this motion. U.S. respectfully requests Judge Eleanor Ross recuse herself from the caption matter. Can't have you here. 11th Circuit Counsel found a subject judge committed judicial misconduct by attending a partisan and political event. And that's really what's the key thing here is, which was reportedly honored Fulton County District Attorney Fani Willis. We didn't know who it was. We didn't know it was you. We didn't know it was Fani Willis, who rose to nationwide fame for her failed prosecution of President Trump for alleged crimes related to the 2020 election. Public reporting has identified the subject judge as Judge Ross. So it's you, Judge. We now know it's you, because this case, U.S. versus Raffensperger, was in front of Judge Ross. The 11th Circuit knew this, by the way, and still kept her identity secret. This is how twisted and sick the 11th Circuit is. They knew that she had this case. Everyone knew she had this case. Serving someone who's reviewing her cases, you don't see this case? And you keep it secret, 11th Circuit? What the hell's wrong with you? I need to stress this again. The 11th Circuit saw all her misconduct, saw how she's approaching and going to parties, breaching her canons of ethics as to how she must conduct herself because she's such besties with District Attorney Fani Willis, and says, oh, we don't see any conflict in any of your cases. Fortunately, we don't see any conflict in any of your cases. Are you kidding me? So we're not going to let anyone know who she is. We're going to keep her anonymous. This is ridiculous. If not for it being exposed, she would have been sitting on this case all the way through the end. Shame on the 11th Circuit. What a complete and total outrage. Humiliation for our judiciary. It's disgusting. It's really hard for me to determine whether the conduct of Judge Ross or the 11th Circuit is more disgusting. How they gave there's nothing. They did nothing to her. And then they basically hamstrung anyone who may be affected by her conduct from being able to protect themselves from that. What a complete disgrace of our judiciary. That's what the 11th Circuit is today. Complete disgrace. The reported misconduct necessitates Judge Ross's recusal because if Judge Ross is indeed the subject judge, it creates the appearance of bias. A judge who attended a party celebrating the election of a Democrat best known for prosecuting a Republican president for alleged election interference cannot then preside over a case concerning the president's effort to ensure election integrity. It's insane. It's insane. The lawsuit concerns Georgia Secretary of State Brad Raffensperger's refusal to provide the U.S. with election records in violation of 1960 U.S.C. 20703. The AG requested Secretary Raffensperger produce information necessary to ascertain Georgia's compliance with federal election law. Specifically, the Attorney General requests that Raffensperger provide a copy of Georgia's statewide voter registration list containing all fields required under Section 303 of the Help America Vote Act. But Raffensperger declined. He doesn't want to give us anything. And we got several organizations, individuals have intervened as defendants, usual suspects like the Southern Poverty Law Center. They brought their motion to dismiss. We opposed, and that hearing is scheduled for June 3rd, 2026, and I don't want you hearing this stupid thing. On December 10th, Judicial Council 11th Circuit adopted. Now, I guess maybe you can rest assured, don't worry, she's not going to be handling it herself, only her clerks will. That's small consolation. On October 10th, the Judicial Council of the 11th Circuit adopted an amended final report. And in that report, it said that you attended a partisan political event, and specifically a district attorney campaign, and the judge had to pass through a lobby area adorned with campaign signs, and was sponsored by the DA campaign or donors to that campaign, and its purpose was to promote Fani Willis. But at the time, it just said district attorney. And after the event, someone sent her a photograph in which the judge can be seen holding a martini glass, in which an appetizer was served. The next day, the judge showing the picture around, she's all proud of herself. Look at me, I'm Fani, I'm at Fanny's party, look at me. Maybe she was shrieking it to her boyfriend. 3 former clerks recalled the subject judge saying the judge had consumed martinis at this party. Final report concluded that subject judge's attendance at the event violated Canon 5, which states that the judge should refrain from political activity. So she was not refraining from that. She is going to that. And this had the potential to erode public confidence in the independent, nonpartisan nature of the judiciary. And it said it appears to be a mere matter of good fortune that this didn't get media attention. Final report also found other instances of misconduct, namely improper sexual activity, meaning, yeah, that she's disgusting and gross, but those are not the subject of this motion. This is just a knock we're going to give you in general by bringing that up. And I guess in case this goes up for review, I guess you put that in there. Why would you put this in here when you're asking her to recuse herself? The 11th Circuit issued a private reprimand. And this ridiculous apology to 6 former law clerks and agree that she would never serve as a chief judge. Forgo service as a chief judge. And indefinitely refrain from service on Judicial Conference Committee. Ridiculous. In the week of May 25th, various news outlets identified Judge Ross as subject judge. Until this, look, this came out in February, but it wasn't until this week, because they filed this on May 29th. It wasn't until this week that we heard this was you. We didn't know it was you. Although the 11th Circuit Judge Ross had neither confirmed nor denied this report, and there's strong evidence the reporting is accurate. Final report indicates subject judge attended the district attorney's political event on the judge's summer intern's first day. And based on the final report's discussion of the layout of the subject judge's chambers, at least one legal expert has concluded that it's very likely that the subject judge is stationed in Atlanta. Furthermore, there was a very high-profile district attorney race in Atlanta that was settled on May 21st, 2024. Fani Willis won the Democratic Party. And Judge Ross served as a senior assistant district attorney in Fulton County, Georgia. So she was an assistant DA under Fani Willis. That would have given her a chance to work with Fani, who was assistant DA at that time. Final report indicates the day after the political event that Judge Ross presided over a criminal revocation proceeding, and that was May 22nd. So she seems to have gotten drunk the day after Fani's party. So that seems to corroborate the belief that it was Fani Willis's party she was at. That's how we're coming to that conclusion. We know she was at a DA's party. We know Fani had a party on the 21st, and we know that she was drunk on the 22nd. And we also know that she's good friends and worked with her. These are good reasons to believe that her good buddy is that the district attorney whose party she went to and got drunk at was indeed Fani Willis. Very logical assertions here by the DOJ. We happen to have the attorneys. The work we see from attorneys from the DOJ under the Trump administration is stellar. It's stellar. They get this out a few days after this becomes public, and they piece together. Oh, look at this. We see she worked with her, and we also see that she's reportedly drunk the day after a Fani Willis party, saying that she was at a district attorney's party. So she never said. The report doesn't say it was Fani Willis' party, but we have good reasons to think it was her, considering their previous relationship. As the district attorney of Fulton County, Fani Willis went on a blitzkrieg rage against Donald Trump, alleging violations of Georgia RICO, and other crimes, which had to do with the 2020 presidential election. And then she appointed Nathan Wade, and you all know how well that ended up. But basically, Fani Willis was another woman who's basically boinking people in her office. All these high-powered Georgian women basically can't keep their hands off the staff. I know what I said. President Trump. I just got a look from Lady Lawgic. She lay in bed. She just rolled over and gave me a look. Sorry, dear. I should have pretended I didn't know what I said. All right. President Trump's co-defendant moved to disqualify Wade and the Fulton County District Attorney Office due to an appearance of impropriety and a personal relationship between DA Willis and Wade. Georgia Court of Appeals currently disqualified Willis and her office from prosecuting President Trump. And the case went down the toilet where it belonged. You probably see them hanging out all the time. Based on reports identifying Judge Ross as a subject judge, and out of an abundance of caution, the United States urges Judge Ross's recusal. We're saying, you got to get out. Look, you can't be here. We can't have you. You cannot be deciding this case. Upon belief that you attended a party, that when they say sub-judge, it means you. And they were attending a partisan political event in support of a district attorney who attempted to prosecute Trump for alleged related conduct, for alleged election related conduct. If indeed you're the subject judge, that gives rise to an appearance of bias, which requires you to recuse yourself from the election related case. Very sound logic. Very, very sound. Quote, any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding which his impartiality might reasonably be questioned. You have a self-enforcing obligation to recuse himself where the proper legal grounds exist. The judge must recuse if an objective, disinterested lay observer fully informed of the facts underlying the grounds on which recusal is sought would entertain a significant doubt about the judge's impartiality. So anyone would look at this, would think to themselves, look, you're friends with Fani, which makes it shady already. And now you're going to Fani's parties, and Fani's the one who was all over Trump and hated Trump for the election and tried going after him for his election-related work, his election integrity work. He tried working election integrity, and she tried prosecuting for it. And now we're trying on his behalf to work for election integrity. It makes no sense that her bestie here should be handling the case. No one would hear this and think this is a normal thing for her to be able to presiding over. Most important, the benefit of the doubt must be resolved in favor of recusal. So when in doubt, you have to recuse. Judge Ross's reported attendance at Willis' election party gives rise to an appearance of bias and necessitating recusal. First, an objective, reasonable observer would say that your attendance at the party is an endorsement of her election. You're happy about her being elected, and you know why she got elected. The reason she's so popular is because she went after Trump. Signs of partisanship detract from the appearance of impartiality that is important to the administration of justice. And they go on and on, basically saying, giving out their arguments here. They say an objective, reasonable observer will construe reported actions as an endorsement of her reelection and Willis's actions while in office. So anyone would think you seem to be very happy with what Willis did. You seem to be very happy with the way she went after Trump. Now you're going to end up signing a case against Trump when it comes to election integrity? The thing she's most famous for is her failed prosecution of President Trump. This case, too, is about election integrity. When the statutes that issued the National Voter Registration Act was passed explicitly for the purpose of protecting the integrity of electoral processes. So, and an objective, disinterested lay observer fully informed of the facts would entertain a significant doubt about your ability to be impartial. If these reports that if the reports that you are the subject judge are accurate, because they don't know for sure. They have good reasons to think it's her. They're reporting on it. There's corroborating evidence to that fact, but we don't know for sure. Judge Ross repeatedly attended a political function for a district attorney who made a national name for herself, prosecuting President Trump for his concerns about election integrity. And for the foregoing reasons, the U.S. respectfully requests you get the heck out. You recuse yourself. That means you basically remove yourself from the case and hand it off to a different judge. That's what recusal means. Respectfully submitted by Harmeet Dillon. Very well drafted, like I said. Stellar work. Stellar, stellar work. And today we saw the fruition of that work. Yes, we did. It's always an intellectual debate until race is injected. Then it becomes an emotional debate. Very, very true. 100%. 100% true. Very astute point. Hands One Pack says, powerful black women love them some 50 Shades of Nathan Wade. That was good. That was very well done, Peter. Nicely done indeed. So you want to hear what Judge Ross said about all this? I don't know. I wonder if she wrote this or her clerk wrote it. I don't know. I got a feeling she wrote this one. We'll put it in pink because she wants to look pretty all the time. So this is what she wrote. Presently before the court is the United States motion to disqualify. The United States requests the undersigned, meaning me, recuse herself from this case under 28 U.S.C. 455 based on finding a report from the Judicial Council of the 11th Circuit that an unnamed judge, since identified as the undersigned, attended a partisan political event hosted by a district attorney's campaign. So you're basically saying I'm the one, and because of that line, you're basically saying I should be removed. The report concluded that the undersigned attended the event. So now she's saying it was me. A private mixer was part of a larger function that was undoubtedly partisan political in nature. The report further determines that the undersigned again is a reference to herself because she's the one who's ultimately signed. When it says undersigned, it means Eleanor Ross, her, right? So she's basically admitting it. This is her, not basically, she is admitting it. She's saying that's what the report said, that I attended an event. The report further determined that I attended only for purposes of reuniting with former colleagues, did not speak publicly, did not make any donation. Now she's going to go through all the things that helped make her not look completely twisted. Did not make any donation, did not otherwise engage in political activity while at the venue, and that the attendance did not appear to be part of a larger pattern of improper participation in partisan politics. So they said that I didn't do that, I wasn't that terrible. Nevertheless, the overarching purpose of the larger event, of which the mixer was a part, was to promote a district attorney's political campaign, sponsored by her or her donors. And the undersigned's attendance at the political event had the potential to erode public confidence in the independent and nonpartisan nature of the judiciary. Based on media accounts, the United States asserts that the undersigned attended the event, likely hosted by Fani Willis, now the former Fulton County District Attorney. According to the U.S., considering Willis's affiliation with the Democratic Party and her role in prosecuting President Trump for election fraud, my attendance at an event hosted by Willis' campaign creates an appearance of bias in this proceeding. And under 455A, a judge shall disqualify herself in any proceeding in which her impartiality might reasonably be questioned. Therefore, the key question is whether an objective, disinterested lay observer, fully informed of the facts underlying the grounds on which recusal was sought, would entertain a significant doubt about the judge's impartiality. So would an impartial person think that I cannot be objective here? Because the relevant inquiry is an objective one, what matters not the reality or bias or prejudice, but its appearance. Okay. Based on this stand, the United States argues that recusal is required under 455 for the following two reasons. First, a reasonable observer would objectively conclude that the undersigned attended Willis events constitutes endorsement for Willis's election and the Democratic Party. And also, they would construe the undersigned's attendance as endorsement of her actions while in office, which include prosecution of President Trump's for crimes related to election fraud, and question the undersigned's impartiality to decide a case in which his DOJ seeks voter rolls in an effort to ensure election integrity. The court takes up each of these arguments in turn below and concludes the recusal is appropriate for the second reason that the United States advances. There you go. Court declines to find that an objective, disinterested person, observer with knowledge of the above described facts would significantly doubt the undersigned's impartiality based on partisanship. But even assuming the objective observer would construe my attendance at the mixer as favoring the Democratic Party, recusal on this basis is not required because this case concerns the federal government's ability to enforce voting integrity laws, not partisan politics. Okay. Notably, the DOJ is seeking to enforce Civil Rights Act in this action on behalf of the Republican administration, and defendant Secretary of State, who is resisting the effort, is Republican and member of the Republican administration. Yeah, sure, very Republican. And so, while the Democratic National Committee has filed an amicus curiae brief in support of Raffensperger, because he's a scummy rat and the DNC loves him, the amici in this case span political parties. Indeed, amici, all of whom appear in support of defendant and intervener defendants, include former employees of the DOJ, many of whom served during Republican administrations. So she's like, the fact that I happen to be exposed as loving Democrats, that doesn't really matter because there's so much bipartisanship in this case. Nevertheless, the court finds that recusal is appropriate based on the unique facts of this case. Specifically, this case concerns Trump administration's efforts to obtain Georgia's unredacted voter registration list in furtherance of Trump's objective to uphold election integrity in Georgia. And Willis is known for her role in the prosecution of President Trump over his alleged interference in Georgia elections. Both the Trump administration's present and Willis's past efforts have become highly polarized. So the court cannot discount the potential that the undersigned's attendance, that my attendance, I cannot ignore the fact that my attendance at an event sponsored by Willis campaign, even if that attendance was only for purposes of reuniting former colleagues, would lead an objective observer to perceive that I support Willis's position. And perceived support of Willis' position on election integrity could cause an objective observer to significantly doubt the underside's impartiality in this case. Therefore, out of an abundance of caution for the potential perception of bias, I, the undersigned, will disqualify myself. She says herself. This is the proper way to be written. The undersigned will disqualify herself. You refer as out of deference to the bench. It's appropriate. Every judge would refer to it this way. In case you're reading along with me, he's saying, she says the undersigned, she refers to herself. She says the undersigned and disqualifying herself, like referring to herself in the royal we. You might think that that is something that's reflective of arrogance or something unbecoming of a judge. No. Every judge would write it this way. Every judge would. They would refer to themselves as the undersigned. They would refer to to themselves as herself. They would write it this way. This is very appropriate way for a judge to write this decision. So she's recognizing that there's a perception of bias based on the fact of the nature of what Fani Willis is famous for, going after Trump for his election integrity, and this being about Trump and his efforts to maintain election integrity. And she says what matters is not the reality of bias, but prejudice, but its appearance. Accordingly, the undersigned grants the United States motion to disqualify and recuses from this case. Furthermore, the court denies its moot the United States emergency for emergency ruling. So ordered 15th day of June, 2026. And there you go. She gone. She gone. I will say this. I've been bashing Judge Eleanor Ross this entire stream. And I still think that woman should be removed. She should be removed because it's an embarrassment to her and to the court to have her, to keep her on. But the way she wrote this 5-page decision, a decision to recuse herself, displayed maturity and was well written. And I agree with the logic of what she was saying. There's much stronger grounds based on the fact of the nature of the case and the nature of what Fani Willis is famous for as creating an appearance of prejudice. That's stronger than the whole political connection. It is. I think political connection probably is enough anyway, but she got there. She got there, and it's relatively well written. And she didn't insist on staying there. Now, perhaps she was advised to come to this decision. I wouldn't be surprised if she was advised to come to this decision, because imagine if she said, no, I'm staying on, and then they would have had a whole hearing about, an application for the circuit court to review it, and then she's going to come back up before the circuit court, and that's a reminder before the circuit court as to just how stinky she is as a human being and as a judge and as a couch owner. So that just wouldn't, it's just probably something she wants to lay to rest, because she knows if I say no, I'm staying on this case, I'm denying your motion and not recusing myself, and I'm going to be able to stay. They're going to appeal to 11th Circuit. 11th Circuit, and in their appeal, Harmeet Dillon and the DOJ would be yelling at the 11th Circuit, we don't know why the hell this woman's still working here. She should be working on some corner in DeKalb County with the nature of how she screams. She should be like on TV hawking couch cleansers for how effective she is at getting stains out of couches. I don't know why she's working as a judge. And she's basically twisted in with Fani Willis, who's election integrity just lunatic when it comes to Trump. And no one would think this is normal. And I think if you're a Judge Eleanor Ross, you probably say to yourself, I don't need to remind the 11th Circuit as to how magnanimous they were in not punishing me pretty much at all. So if I just get out of this case now, we stop talking about this. But it meant that she had to publicly acknowledge that it was her. Right? In other words, she could have said, she could have just denied. And that would have started, she could deny it was her. I guess she felt like that might have pissed off the 11th Circuit if she denied it. That probably pissed her off if she denied it. So she probably didn't have much choice here. I think it was probably politically astute for her to do this. But to her credit, at least she got the right answer, that she had to be gone. And hopefully the DOJ is successful in this case with a judge who is actually fair and impartial. And that's what I got for you tonight. That's what I got for you. Unfortunately, we did not reach our goal tonight. It didn't happen. But that's okay. I'm back here tomorrow evening with Sin. We'll be rousing it up there. Summer Breeze says, now that this is public, specifically that her clerks wrote most judgments, how does this affect past rulings that came from her office? Are they subject to be overturned? Nope. No chance. Clerks write a lot of decisions. The point is that she has to read them, review with them, agree with them. She has to read, review it, and agree with it. You're never going to be able to say this case is one she didn't read. We'll never be able to prove that. Even if she only looked at 30 or 40% of them. It's not like the ones that she didn't look at are stamped never checked by Ross. So all of them have the superficial face of being handled by her. It's very, by analogy, just consider it, her signature there is kind of like the Biden pen, the Biden auto pen, right? So you don't know which ones he agreed to and which ones he didn't agree to. And there's going to be a general assumption that the one you're holding in your hand is one he agreed to, until you can prove he didn't. So any decision that you're getting from her office, from her coming out of her chambers, even if it doesn't have any fluid stains on it, you got to assume that it came past her desk and that she actually reviewed it, agreed with it, and stamped her signature on it. And Joe be going to chambers early tonight. Lady Lawgic will be doing law review with him. It is an early night tonight. This is true. This is true. Antithetical to what a judge is intended for. Of course, everything about her is antithetical to what a judge is intended for. This is a humiliation for her, the 11th Circuit, for everyone. I'm glad that it's such a blessing that her name came out. The 11th Circuit is shameful for trying to protect her the way they did, considering the level of misconduct that she engaged in for years, and then tried covering up. Frankly, attending the political event is like the least of it. That's a blessing. Because if she didn't go to that event, we would never have known how biased she is. I mean, just think about that for a second. If she didn't end up going to that event, she got sick that night, didn't go, she would have had the same relationship with Fani Willis, and we never would have known. Her attendance at the event, all it did was serve to basically Fani Willis helped get her out of this case by inviting her to that party. Because otherwise, if Fani Willis didn't invite her to that particular party, no one would have known that she had a prior engagement and couldn't attend. No one would have known that she's besties, and that he might have speculated, and she would have been on this case, and then Harmeet Dillon probably would have lost. So that ended up being a blessing. And even if she was like this, sex freak in her chambers, we never would have known that, that would disqualify her for this case. I mean, it should disqualify her as a judge, but clearly the 11th Circuit disagrees with me on that. And that's what I got for you tonight. Thank you so much. Join me, God willing, tomorrow evening. I will be back here with news, insight, perspective, 50 Shades of Brown, according to Whittick Mike. And yeah, and right now all I got left for you is a reminder that lab meat was never meant for you. It's for they, them. So and I also remind you to stay off of stain cushions and do not eat the bugs. Just don't do it. Don't eat the bugs. Have a good night, everyone. As always, Godspeed.